And as promised, let's first update you with the proceedings in court. Counsel for Uddhav faction has said that the governor in fact acted without even asking the chief minister of his views. Few MLAs of the ruling combine are currently abroad. Some are down with COVID, and therefore MLAs cannot be expected to arrive in the assembly in short notice. The points are all right there on your screen on what Uddhav's counsel had to tell the court. The counsel further says that the governor cannot be seen to be short-circuiting proceedings. Also referring to the disqualification notice to 16 MLAs, the counsel argues that that notice cannot be ignored and a floor test cannot be held on the aid and advice of the opposition. Now, to this, of course, the counsel for the Eknath Shinde faction has also submitted its arguments, where counsel Neeraj Kaul refers to the Nebam Rebia judgment, saying that the court had earlier held it was constitutionally impermissible for a speaker to adjudicate on disqualification petitions under the 10th schedule, while a notice of resolution for his own removal from office was pending. Also talking about how the seat of the speaker is vacant since Nana Patole resigned from office in February 2021. Hence, there is no authority who can currently adjudicate upon the disqualification petition. That's the argument made by the Shinde faction. The disqualification proceeding, according to the lawyer of Eknath Shinde, is not maintainable. Further, the counsel argues that a body of Supreme Court judgments had earlier laid down that the floor test must not brook any delay, and disqualification proceedings or resignation of MLAs cannot be a ground for delaying a floor test. What he also adds is that if you are so confident, then go ahead with the floor test. What is being sought now is by a hopeless minority within a party who do not want to go through the floor test. So those are the arguments and counter-arguments, putting it all out on your screens for easy understanding of our viewers. But let me, in fact, first play out what Mr. Eknath Shinde said on the issue of MLAs now moving out from Guwahati. Here it is.
हम लोग कल मुंबई पहुंचेंगे, ट्रस्ट कोर्ट में शामिल हो जाएंगे। उसके बाद हमारे विधायक दल की बैठक होगी। उसके बाद आगे की जो स्ट्रेटेजी है हम लोग फाइनल करेंगे। हम बागी नहीं है, हम शिवसेना है। हम बाला साहब ठाकरे जी की जो शिवसेना है, उनका जो एजेंडा है, उनकी जो आइडियोलॉजी है, उसको हम लोग आगे ले जा रहे हैं। एक हिंदुत्व की आइडियोलॉजी और डेवलपमेंट, ये राज्य की डेवलपमेंट के लिए हम लोग काम करेंगे, राज्य की प्रगति के लिए हम लोग काम करेंगे।
Well, before we go across to our reporters on the ground, let me introduce, joining us here on the program, Ashwini Dubey, advocate of the Supreme Court. Good evening, Mr. Dubey. Thanks for joining us. I'll just come to you with my questions on certain very, very important and critical issues that have come up in court. But first, taking a quick update from our correspondents, Ketan Vaidya and Meenakshi Bhanja. Meenakshi, the big takeaways for our viewers, please, and what is the status of the hearing at the moment?
Well, as we speak, Senior Advocate Mr. Neeraj Kaul is continuing with his submissions. We have a very important query coming in from the Supreme Court bench, as we have consistently showcased to our viewers all the important takeaways, the twists and turns, the queries. Remember, query is what the bench wants to be satisfied on. So this query going out to this time Advocate Neeraj Kaul from the Supreme Court, the bench wanting to know a hypothetical question, which the bench says that it asked Dr. Singhvi as well, that can there be a situation against democratic morality that the government, knowing it has lost majority, is using the office of the speaker to issue disqualification notices. Neeraj Kaul satisfying or trying to satisfy the bench, saying that the Nebam Rebia judgment of the Supreme Court is exactly on this point. So what is at stake here is constitutional morality that the Supreme Court is concerning itself with as we speak, because remember, on an earlier occasion during the course of proceedings, and we underline for our viewers, these are extraordinary hearings that the Supreme Court is conducting. This is a vacation bench composition of the Supreme Court led by Honorable Justice Suryakant, and it convened this hearing at 5 p.m., which is well past the working hours of the Supreme Court. It is continuing till 7 p.m. This is 2 hours over the working time of the Supreme Court. But these are extraordinary circumstances because the floor test has been called for tomorrow. We brought to our viewers arguments by Dr. Abhishek Manu Singh Singhvi, which Afrida you referred to very correctly. You summarized it for our viewers, where Dr. Singhvi's main focus was as to how the governor purportedly is exceeding his jurisdiction, because primarily he seems to be acting on the aid and advice of the leader of opposition, which is not mandated as per constitution. He is supposed to act on the aid and advice of the chief minister.
So basically, Meenakshi, from what you tell me, both sides are saying that constitutional positions are being misused. One side saying the governor's office is being taken advantage of. The other side is saying the speaker's position is being taken advantage of. Thanks for joining us. Quick update from Ketan as well. Ketan, on the movement of the MLAs. Where exactly is the Shinde camp headed? And what exactly is their plan of action? Are they going to straight land up in the assembly for the floor test tomorrow? What is their plan?
Well, the plan that we are gathering is they are going to Goa, and then they will be headed to Mumbai. So clearly the Shinde camp is confident, from at least what we have heard from Shinde and Deepak Kesarkar so far. We are yet not sure, like absolutely sure, whether all the MLAs, all the dissident MLAs will vote in favor of the Shinde camp. So, and right now, as we speak, my colleague Meenakshi Bhanja pointed out what Justice Kant has asked Advocate Kaul, that can there be a situation against democratic morality that the government, knowing it has lost majority, is using the office of Speaker to issue disqualification notices. So the Supreme Court wants to make it clear that the incumbent government, knowing that it has a minority, is using the disqualification clause or not. Now, yes, this is an extremely important argument on which the whole case rests. Because as you know, the July 12th hearing is all about the disqualification notice that the Speaker has issued, and in return of that, the rebel camp has expressed a no confidence motion in the reigning Deputy Speaker.
Okay.
So
yes,
these are all procedural matters. However,
yes,
whatever decision
but the action might
Supreme
shift
Court
to
takes
Mumbai. That's what you're telling us, Ketan. That perhaps it's a pack-up from Guwahati, as far as we can see, with the MLAs exiting the hotel, and the action can now shift to Mumbai. And of course, what the court says and decides as the hearing is underway, we'll keep taking updates from Meenakshi. Thanks for now, Ketan and Meenakshi. Thanks for joining us. So coming to you, Mr. Ashwini Dubey, you heard it all laid out for you. I just want you to tell us that, you know, as of now, the submissions from both the councils, it seems, is harping on the fact that one side is taking advantage of the position of the Speaker. There's an overreach of the jurisdiction, as my colleagues were telling us. And on the other side, the role of the governor, where Mr. Singhvi, Dr. Singhvi says that the governor cannot act on the aid and advice of the opposition. He should actually have taken the advice of the Council of Ministers. Where do you stand on this, Mr. Dubey?
There are three legal principles which is to be looked into, keeping in with the constitutional provisions, keeping in with the various landmark precedents in judgment of the Supreme Court. The floor test upholds the collective accountability of the elected government to the legislature, and principle of democracy enshrined in the constitution demands that the issue whether the government commands the confidence of the House be left to a vote in the legislative. So there are two exceptional circumstances. There are either the incumbent government, when the question whether an incumbent government enjoys the support of the majority of the member of a legislature is the sole prerogative of the governor of that state. And it is also a well-recognized principle that a floor test within the shortest possible time is the appropriate measure where any doubt arises over whether an incumbent government continues to enjoy the support of the majority of the legislative assembly. There are two ways to conduct the floor test. Either when the session is in motion, session is taking place, then by moving a no confidence motion, and when session is not there, then by requesting the government and governor. Governor has two legal discretions. One, if it appears to the governor that the incumbent government does not enjoy the majority, governor under Chapter 6, Part 6 of the Constitution under Article 174 may also take a decision. This is a discretionary power and courts have already held it. And not only this, not here, in the Shivraj Singh Chauhan's case, Supreme Court has said that the governor is empowered to issue a direction to an incumbent chief minister to hold a floor test and to demonstrate the legislature's trust in their government. Now, another point is, what Supreme Court has raised three important questions. One, where is there any minimum time to hold a floor test, which is their argument that in the shortest period of time, without giving enough opportunity or enough time, they have taken this decision in haste. Second, is there a constitutional bar on holding a floor test? Third, is there any provision in the constitution that bars a floor test from being held with respect to the disqualification petition, which you are referring the second question, that so far as the role of office of the speaker is concerned, where is the bar? Court says, how does the floor test depend on qualification or disqualification? And I think the answer lies here, because ultimately, it is the governor's office when it appears to the government, because the state's constitutional head is the governor. Governor cannot allow the government which is not in majority to run, because
but the governor at this point, like you said, has the prerogative to call for a floor test. But the moment he does so, the role of the speaker is activated, in this case the deputy speaker, since the appointment of the speaker never happened. So there again, don't you think the prerogative will then shift to the speaker, and then he gets to decide who is qualified and competent to vote in the floor test and who doesn't? Doesn't the prerogative then shift to the floor of the House and to the speaker then, as per procedure?
Of course, the constitutional provision says that it is the speaker who holds the entire proceedings and take care of the affairs of the House. But
yes.
When under Article 179C of the Constitution of India, the motion for removal of speaker or deputy speaker is pending, then two discretionary powers are lies. One, either the court will appoint the pro tem speaker with the authority to hold the floor test, or the governor will take a decision. The senior most member of the House shall be appointed as a pro tem speaker to look into that. This is a constitutional provision, and we have seen, and two. Yes.
There is other element also. This is very interesting what you're saying, that, you know, there is a very strong possibility of the appointment of a pro tem speaker, since the position of the speaker itself is being challenged. His continuance in that post is being challenged. So that decision is also pending. Therefore, even though he has the prerogative, whether in this case he will have it or not is not sure at the moment. There is clarity awaited. The other element I want you to also throw some light on is the issue of the chief whip. Does that come in at some stage, where if you vote against the party chief whip, you automatically disqualify yourself? Does that element also come into account?
See, the whip means one has to be present inside the House, or one whip means to command to do certain act. Suppose there are two fractions in the Shiva Sena. One Shiva Sena is led by the Uddhav Thackeray ji. One Shiva Sena is led by the Eknath Shinde ji. Eknath Shinde, admittedly, as per the media reports and the statements made by the fraction led by the Shiva Sena led by Eknath Shinde, it appears that he enjoys the majority. So in that eventuality, if the chief whip appointed by the majority at that point of time and not removed, passes a resolution, and any member of that legislative assembly and that belonging to that political party violates it, that's subject to the disqualification as given.
Which is why, you know, it is absolutely unclear whether a floor test should be held, where the court is yet to decide on who the competent authorities are. If their positions are challenged, shouldn't that be first settled before we even go to a floor test? Well, that remains to be seen, but I would like to thank you, Ashwini Dubey, for joining us this evening with all your informed opinion on the subject. Let's take a short break. When we return, the outrageous story of two sisters being assaulted and stripped for not being able to repay their education loan of one of their daughters.